crime is not a problem. Crime is a symptom.
Right.
So obviously, a crime has massive negative effects, especially a violent crime. It is life-changing or life-ending for the victim and for the victim's family. And it's life-altering for the family of the accused and often life-altering for the accused. But these are symptoms. If you see a spike in larcenies that tracks with a spike in poverty, maybe those two things have something to do with each other.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, before we get into the podcast episode, I want to take a minute or two and introduce you to a friend and colleague, Jenny Shadini. Jenny is a former prosecutor from Baltimore City, and now she works as a settlement consultant. We work with her often on helping our clients really maximize their results. Jenny, it's really great working with you and having you as a supporter of the podcast.
Thank you, Sharif. Hi, everyone. My name is Jenny Shadini, and I work as a settlement consultant, which means I work with attorneys and their clients in various settlement planning needs, such as structured settlements, whether or not to utilize a trust, how to protect government benefits, and overall providing financial security to your clients.
And Jenny, how could people get a hold of you?
The best way to reach me would be my cell, which is 301-332-1031. Again, that's 301-332-1031.
All right, we're back, RVA Trial Lawyers, and today we have Ramin Fatehi. Ramin and I actually connected in a very unusual way. At VMI, I took an English class with his now wife, Mary Beth Pennington, and it's a small world, and we eventually made that connection through that, and Ramin and I have been in touch over the years. Ramin is the Commonwealth Attorney for Norfolk, and large jurisdiction, tons and tons of cases, and has quite a background, having been on both sides, public defender in Richmond, Commonwealth Attorney in Norfolk, and has done quite a bit of good and definitely pushed, I think, the ball forward in terms of criminal justice reform. So really excited to have you. If you wouldn't mind, go ahead and introduce yourself real quick.
Hey, I'm Ramin Fatehi, and you said it all. I'm the Commonwealth Attorney in Norfolk, and since the first trial I had as a lawyer was in Richmond, I guess that makes me an RVA trial lawyer.
That's right. That's right. So we're excited to have you. So one of the cool things about at least this podcast is that we've got civil lawyers who join us from around the country to include Virginia. We've got criminal lawyers who join us, and we're learning from them all because at the end of the day, a trial is a trial. So at some point, probably maybe towards the end of our session together today, would love to get into your thoughts on effective trial practice and best practices and all that. But before we do that, I know Niall's itching to get into your background. So Niall, go ahead.
And there are no better trial lawyers than prosecutors. So, but I'm partial. So that's the majority of my career. So Ramin, let's talk about Ramin as a child. Tell me a bit about what's your background? Where are you from originally? Or family, at least?
Oh, that's a complicated question. So my dad's from Iran, which is great. This makes this an all Middle Eastern RVA trial lawyers episode. But
that's right.
My mom grew up in the New York metro area. Her parents were from Brooklyn, and she grew up in New Jersey. And mom and dad met in Washington when dad was doing his neurosurgery residency in the 1970s. And then mom and dad moved back to Iran in 1977, which was extraordinarily poor timing. Not that anybody can tell the future. I was born here in the U.S. because my parents wanted me born in the States, but I went back to Iran when I was a month old, and I lived there until 1985 and came back shortly before my 7th birthday. So then I did my first grade in Iran, and then my second grade bouncing around public schools in various parts of Virginia, and then we settled in Hampton Roads and in Virginia Beach in late 1985. So I'm Iranian, I'm American, and I'm Iranian American.
You're right. That's a great observation. We've got a fully Middle Eastern podcast right now.
I may have a little more in me than both of y'all, but let's continue on. So you came here, young age, grew up. Why law? What led to you saying, hey, my dad is a neurosurgeon, a doctor? Did you just have the option of being either a doctor, a lawyer, or engineer, and you fell number two, or what was it?
Yeah, that's right. I mean, for the non-Middle Easterners listening, like, first of all, if you only have a bachelor's degree, you're a shame, and you're a disappointment to your family. But yes, there are only a limited number of acceptable career options. I'd gone to college thinking I was going to be a foreign service officer, and I did some of that work one summer during college. And as fate would have it, my college girlfriend's father was a U.S. ambassador, and I think, like a lot of other people in mid to late career, all he wanted to talk about was like all the bad parts about it. So all of a sudden, as like a rising junior, I was like, well, I'm not going into the foreign service. What am I going to do? And I was like, well, law school makes sense, which said only people who don't know what law is. And I went straight through from college to law school. My family is mostly doctors, but my father's sort of patriarch uncle was a criminal law professor at Tehran University and was one of the authors of the Iranian Penal Code in the 1930s. So we did have some lawyers in the family. He was also a minister in the Mossadegh government in the 1950s. But so it was don't disappoint us by only having a bachelor's degree. B, I didn't feel like doing all the pre-med prereqs, and C, why not do this?
And then you got out. Tell us, right after law school, what did you self into?
The first thing I did, I summered in Richmond at Hunton 2 summers, 1.5 summers. Didn't particularly, Hunton's a great place, but I'm not a firm lawyer. And then I clerked in Richmond again. That was my second stint in Richmond. Then I clerked for Justice Lacey at the Supreme Court and used that time to connect up with RVA trial lawyers, the late Esther Windmuller, and my cousin, Ali Amirshahi, who is now your fellow judge, one judicial district over. And
great guy.
Then coming out of my clerkship, I intended to be a prosecutor, but it was such a different era. It was like, don't even apply until you can start in 2 weeks. And so I applied as a hedge to some AmLaw 100 firms. And at the end of my clerkship, I wound up with an offer to be a prosecutor in the city of Portsmouth or to go to Kirkland & Ellis in Washington. And Kirkland offered me a clerkship bonus that was about half of my year's salary as a prosecutor. And it's like, Kirkland to Portsmouth seems more probable than Portsmouth to Kirkland if I don't like being a prosecutor. So I went to Kirkland, did pharmaceutical antitrust, did ERISA, was not enjoying it, and walked away from it all and had help from Ali Amirshahi and walked into the Richmond Public Defender's Office.
We both ran away from big law.
Well, we're not the only two. There's a lot of people who do that. So I'd say we could create a club, but it would be overwhelming. No, I mean, what I noticed is, you did go to, Yale, then Columbia, right? And then took kind of the traditional path to, you did big law and now found yourself in doing public defender work, which is obviously a massive shift from, I'm sure, the work you were doing at Kirkland.
It was a massive shift in my happiness. I went from feeling as if I was helping rich guys argue over bags of money or having rich guys with obvious exposure jamming up poor people by running up transaction costs to the point of exhaustion for the plaintiff's bar. I just did not feel morally invested in the work. And no disrespect to, all the great AmLaw, partners and associates out there, but I needed something more. And representing indigent people, to be able to serve in that way, and just be able to be in court. Those were the things that really motivated me. And be able to work with some of the, real giants of the Richmond bar and the Richmond area bar, to be able to hang out with like Rocket Charlie and Carrie Bowen. And, at that point, Ali, now Judge Amirshahi, shared office space with Craig Cooley over on Idlewood Avenue. The list would absolutely go on of the people with whom I got to work. I should add, as an aside, one of the senior public defenders when I came to Richmond was a guy named Scott Miles, and Scott was known as Mr. Perfect in our office. That was his nickname, and now Scott and I work together in Norfolk. and he is one of the deputy Commonwealth attorneys in my office. So I got to work with just a tremendous group of people, and then try cases against people like Elizabeth Hobbs and Jenny Nesbitt and John Jung and Tony Pham and Colette McEachin when Colette was the GDC supervisor. So it was just a tremendous experience. And then the trial side aside, the three of us have all, we've all done all right in life. And, part of it is hard work in industry, and another part of it is just good luck, being born to the parents we had and in the circumstances we had. And to have the accident of birth, what the moral philosopher John Rawls calls morally arbitrary factors, your race, your sex, your age, your level of intelligence, whether you're disabled, or whether your parents are helicopter parents or absent. To see people who were not so much different in age than me, especially the children, who were just as smart, just as industrious as I was, and also just as impulsive as I was. And to be able to see myself in them, and then to be able to go out and to try and equalize some of the unfairness that they experienced through no fault of their own, that was really deeply morally fulfilling. And I tell my prosecutors that being a public defender was one of the most important things for my career as a prosecutor, even though I only did it briefly. And it's a reason why I have a strong preference for hiring former public defenders and defense lawyers in my shop.
I think it makes a huge difference. Huge difference. Now go ahead.
And why is that? And I know why, but I want the listeners to know why.
It depends on whether you want to talk about the light side of the force or the dark side of the force.
Well,
the light side, I'll talk about both.
Yes.
The light side is that there are certain myths in the prosecutorial community, like the myth of client control, like the myth that the defense lawyer can just get the defendant to do whatever is rational or whatever the prosecutor wants them to do. Or that framing the discussion about a given case like a T14 law grad is going to work in a lot of the cases that we do as criminal lawyers. The prosecutors who have not defended before are capable of picking up these ideas, but it's harder in the sense that experiencing something versus reading about it is harder. So what I tell a lot of my young lawyers who haven't been defense lawyers is, look, if your offer is this, like if you package it by method A, that defense lawyer is going to get chewed out and you're going to get your offer rejected by the defendant. If you frame it by method B, that recognizes like the complexity of the client-attorney relationship, especially in the world of appointed work, where the client doesn't have money invested in believing that his lawyer is right. You go by method B, you will get to yes. The exact same offer, A and B, rejection here, acceptance here, if you know the psychology of the work. The dark side of the force is this. And this, by the way, goes for prosecutors who turn defense lawyer, too. We know where the pain points are. Like, I know where the pain points are in a defense case. I know the things that a defense lawyer may feel as if they don't want to be bothered to do if they're not the greatest defense lawyer, or the things that are really going to, I know what the hot buttons are going to be, and I don't generally want to push them, but I know how not to push them. But if you've been a prosecutor and you've been a defense lawyer, you know exactly like which anxieties you can play on as a defense lawyer. Hey, are you sure you subpoenaed everybody in a timely way? Are your witnesses really going to show? Do you think? You're missing a link in that chain. You think you're going to be able to connect it. You sure? And especially if you're older and you're dealing with a younger lawyer on the other side, the dark side of that force, the ability to recognize how to get your opponent to yes by knowing where their weaknesses are. That's another thing that you only get from doing the other side. So, but probably beyond all of that, it's the empathy factor. A lot of prosecutors just treat defendants as perps or as monsters, and it's it's eye-opening to sit down and talk to somebody who's in jail without bail in a jumpsuit, especially if they've done something really wretched and horrible, and to be able to have like a relatively normal conversation with them and to recognize that we are all a mixture of good and bad. And, to use that to temper the immense power we have as prosecutors, to make sure that we're applying force as necessary and in a rational way, and not just out of a desire for vengeance.
The prosecutor arguably is the most powerful actor in the courtroom. And every time, I've walked into the courtroom and I mentored younger prosecutors, I tell them you walk in with the philosophy that your goal is to put both the defendant and the victim in a better position in the way out of the system than into the system. And if you're not able to do that, you get as close as possible. And you touched on the blessings that you and I, and also Sharif, ask ourselves, why were we born to parents that love us and care about us and that have spent time to teach us the difference between right and wrong? And a lot of those defendants that we see, they don't share the same blessings that we share. And it's how do you take that into consideration when you're making that offer or when you're saying, hey, we're going to, even a charging decision. And I often say, if you're a great prosecutor, you don't need a defense attorney on the other side. Because as a prosecutor, your job is to pursue justice and represent the community, and the defendant is part of the community. What does a prosecutor mean to you?
Well, we're ministers of justice. As you pointed out, our client is a greater idea. It is the idea of being fair, both procedurally and substantively fair, and of promoting what are sometimes conflicting goals, which is greater safety, rehabilitation, a healing of someone's trauma. Often ideas that where you can't get all of it all at once. But we are the most powerful actors in the justice system. I mean, that's part of the reason I walked away from being a public defender and have devoted now nearly 19 years of my life to being a prosecutor. It's because we have the power. What I tell my lawyers, especially my young lawyers as I train them, is that as prosecutors, the exercise of our power in a measured way is the test of whether we are doing our jobs right. And I say that as a defense lawyer, I always had to argue. I had to try my case in hot blood, appeals to emotion, passion. As a prosecutor, we have to tamp down those things. We can flash righteous indignation, but we can't flash anger. It's the old hard blows but fair. And when it comes down to individual cases, when you talk about advantage versus disadvantage, this is sometimes an interview question I use. And I pose hypotheticals to people. And I'll spare you the hypotheticals, but basically it creates a 2x2 matrix. And if you want to have, on one axis, you can have intelligent, developmentally disabled, or privileged, not privileged. Whatever you want to put on that side, as far as, good judgment, bad judgment. And then on the other axis, I put crime of impulse, crime of premeditation. So how those two things interact is the basic rubric for my prosecutors and for me. Because think about it this way. If you have someone who steals $5,000, that's grand larceny, right? And that's typically felony level grand larceny. Now, what I tell people in the interview is, tell me what you want to know. Like, what do you want to know? And, obviously they say criminal history, they say this, they say that. And a lot of times they don't ask me about the facts or really about the defendant. And I say, well, let me give you a for instance. Let's say the defendant is 19 years old and he wheels a $5,000 TV out of Walmart where he works as a cashier. And he has a 65 IQ and lead poisoning and grew up in foster care. Now, let's then look at that same $5,000 and have it be the chairman of the University of Richmond history department who embezzles that money out of the travel fund. are those two cases congruent because of the dollar amount? So how does the fact that it is a crime of premeditation intersect with the cognitive tools, privilege, initiative, judgment, whatever you want, when it comes to the question of mitigation or aggravation? And then what I do is I flip it on its head and I say, okay, I'm going to take your same 19-year-old and your same history professor, and your 19-year-old breaks a bottle over somebody's head in a bar because they say they talk trash about the guy's girlfriend. And then how about the same thing for the history department chair? And they talk trash about his girlfriend and he breaks a bottle over their head. Now what is the matrix? Who gets, which one is aggravating and which one is mitigating? And, in the interest of time, I'll just say that I generally tell prosecutors that if you have a relatively quote unquote privileged, intelligent, advantaged defendant who commits a crime of premeditation, then their backstory is an aggravating factor because they have the cognitive tools and the alternatives to avoid doing this. And if the person doesn't have the tools, then that is a mitigating factor, at least in terms of their blameworthiness. Now, restitution's restitution, but in terms of like who really gets a break and who needs the hammer. But then you flip it the other way. The history department professor who breaks a bottle over someone's head and gets charged with malicious wounding. So everybody can lose their temper. Does that person get a felony conviction, assuming that there was no permanent injury or serious injury to the victim? What about the 19-year-old who, setting aside the moral blameworthiness, it's relatively clear that that person is going to have a very hard time governing their impulses because they have developmental disabilities. So the moral blameworthiness may not be different, but the sentence may wind up being longer because there is a confinement component to it, a public safety component that may be divorced from the moral element, but that's necessary to protect the public. So that was probably a longer answer than you wanted, but that is the basic framework for how I tell my prosecutors they need to be thinking about cases.
So from your position as the Commonwealth Attorney for Norfolk, how do you manage? Like, how do you make sure that the people that you have carrying out your mission in the courtroom day in, day out are thinking those things and making the right judgment calls?
Personnel is policy and policy is policy. On the personnel side, my office is one of the biggest in Virginia. I think I'm probably number 6 in head count out of the 120. So we have 40 lawyers and 45 staff. And I was very careful and very intentional in picking my chief deputy and my deputies. And unlike a lot of other offices, my deputies only try 1 or 2 cases a year, and only at my direction. They are not so-called working deputies. They are managers and teachers and coaches, and they'll sit as second chairs, they'll sit in with people. But I have 7 senior assistants who are my murder dogs, who do all of this work. So I have relatively close oversight from my deputies and from my chief deputy. That's one piece. I have meetings once every 2 weeks religiously with my deputies and chief deputy and with that group and with my senior assistants to communicate with them about what I'm interested in and what we're doing. I have a 1-stage interview process. The way you get a job in my office is you sit down and you interview with my chief deputy and with me. And that's it. Well, then I make the decisions. And that means that everybody understands that when they walk through the door, they've had a conversation with me, usually an hour to an hour and a half long. With my chief deputy and me. And that means that my lawyers tend to have a relatively direct bond with me. I go to court, which is pretty unusual for a prosecutor in an office of my size. So I go into the courtroom with them. And then I keep relatively close tabs on what goes on with cases through my communications arm. I put out 220 press releases last year to be transparent about the work that I was doing. But what that means is I look at the docket every day and I'll pick up the phone and say, hey, bro, like, what was up with that case? And I pull it up in the case management system. Like, why do we why do we have like a whole bunch of mandatory time on the table on this case with this amount of drugs and no prior record? What's going on here? So they know that they're going to get questions from me. And then the last way is by having very, very clear written policies. I took a page out of the Justice Department because I worked at the U.S. Attorney's Office in Charlottesville. Sharif, that's actually how I met Major Pennington. I was working in Charlottesville when she was at VMI. And DOJ has their charging policy. I don't know if they do now. God knows what they're doing now. But like, back in the era of the rule of law, they had their charging policies and sentencing policies like up. And I'm, to my knowledge, the only prosecutor in Virginia who has my plea agreement policies, philosophies, and procedures published on my website. And it's 10.5 single-spaced pages that is meant to be legible to an educated layperson, where it's not just do this, don't do that. It's, this is the principle. Children and adolescents don't become fully developmentally online until about the age of 25. Therefore, we have a presumption against sending children to adult court because they don't belong in adult court. Obviously, it's a longer preamble in the written version. Therefore, any prosecutor who wants to take a child to adult court has to have me sign off on it. And then I have to sign off on the sentence. So the policies like that to say, this is what I believe. This is how I want you to carry it out. And this is why I want you to carry it out that way. And and you'd think that my prosecutors would claim that they were, they believe it or not, they still, well, of course, they probably tell me whatever they think I want to hear, but they say they still have a lot of play in the joints with their cases because 40 prosecutors cover 4,000 cases a year, but they get pretty clear guidance from me, and they know my mind that. It's not about the win, quote unquote. It's, are you doing the right thing and are you doing it in the right ways? Because I make promises to the voters, and the voters are going to call me out if you go off and start freelancing and violating my promises.
I've worked in a number of offices, CA offices throughout the Commonwealth, and Sharif knows my goal is ultimately be CA, right? And I always thought about, in my mind, how to run and lead an office, because we can be great attorneys, but we're not great leaders. So let me bring you back, and I'll tell you, I commend you, and I'm listening to you speak, and I'm like, he's doing amazing work in Norfolk, and your prosecutors are lucky to be led by you and the philosophies that you have in place right now. And also the community, not only the victims, but also the defendants. But let's talk about the leadership part. How do you lead your prosecutors?
I try to lead by example. And you're right. Leadership and management are very different from trial work. One of the biggest problems in prosecutors' office management is that people sort of ascend to supervisory rank by being good trial lawyers, generally.
Accidental managers or accidental leaders, right? It's the same issue in big law.
Yes. Yeah. And frankly, some of the attributes that make somebody a really bang up trial lawyer tend to make them a really shitty manager. Mm-hmm. And then the typical management route, if you're a deputy or a chief deputy, and I mean, if you're in an office like Charlottesville that has 6 lawyers, like everybody has to go to court all the time. But the management structure is very different than Henrico or Fairfax or Norfolk or Virginia Beach, where you've got dozens and dozens of lawyers. So if we talk really about the larger offices, like we take somebody, we make him a deputy, and then we give him a full murder caseload, and then tell him to watch out and make sure the ducklings don't accidentally swallow bottle caps. And, it's a prescription for burnout. It's a prescription for bad management. And this is another thing I learned from doing federal work. In federal practice, like the criminal chief or the managing AUSA or the first assistant, they don't make any more money. They all make the same salary as the line assistants. And there's absolutely no shame in people rotating in and out of management. In fact, one of the greatest lawyers I ever worked under, a guy named Steve Flager, Pfleger tried 200 murders in D.C. before moving to the Western District of Virginia. And, Pfleger said that he'd get pulled into management every few years, and all he would do was dream about going back to be a line prosecutor. And he would do that. So I've tried to sort of instill in my office, for example, that you don't get to be a deputy necessarily by being the greatest trial lawyer, even though, like Scott Miles, great trial lawyer. You become a deputy because you have an interest in strategic thinking. And that's a whole other discussion. Like I tell my lawyers that, as an aside, that I judge them on their ability to understand where their file fits into the greater life of the city, both in terms of the defendant, in terms of neighborhoods. I'm set up based on geography, not on practice group. And so what I want out of a deputy is somebody who can teach a young lawyer how to lawyer. Belichick does not need to throw, let's talk about Belichick 20 years ago, not Belichick and his girlfriend now, but nobody gave a whit whether Belichick could throw a tight spiral. All they care about was could he coach Tom Brady? Different skills. But I tell people, the deputies are meant to be strategic thinkers. And then the senior assistants are meant to be trial lawyers. And I've got another Richmond OG for you, Andrew Culp. Culp is one of my colleagues. And came down. Judge, you probably remember when he pieced out on y'all. And it was no disrespect to y'all. He loves Norfolk, so he left. And that guy's been a deputy. And when I interviewed Cole,
I had a murder case with him. He left me high and dry.
I'm sure it was personal. Hey, you got Allison Martin. She's excellent too. Yes. But and a good friend of mine, very good friend, Allison. But Culp, when I interviewed him, he said, "Dude, I'll be a deputy if you want me to be a deputy. I can do it, but that's not really my thing. I just want to be trying cases." And he's an ideal senior assistant. There's a small differential in pay between those two ranks in my office, but not enough that it makes or breaks people. And so another thing that I've really fostered is if you're a great trial lawyer, you want to be a great trial lawyer, I will not subject you to management, to being a manager. But if you one of my deputies is actually one of my younger colleagues and a great trial lawyer. And he said, "You know what? I'm interested in being considered for a deputy spot." This is when one of my other deputies, who was learned, a former circuit court judge, retired. And my current deputy said, I never thought I would be able to say this, but I'm really enjoying the teaching aspect of it. And I'd like a break from the psychological beatings of doing all of these heinous cases all the time. I'd like to be a teacher. And he's done a fantastic job. So sort of destigmatizing the idea that if you're not a deputy, or in another way, if you're not on violent crime, then you must not be a good lawyer. To be able to walk people away from those ideas is really helpful in management. But from a personal point of view, what I say is I make the hard calls. I tell my lawyers I'm not going to make you do anything I wouldn't do. If there's going to be a battle with a judge, I show up and I fight the judge personally. I don't send my people in there to do it. And and I tell them, I'm I can go in there and I can trash talk that judge in a way you cannot. So let me go in there and do it because that's my job, and it's my job to protect you.
How do you keep your prosecutor? Because one of the hard parts about this work is that you're constrained by what the government can pay, the shrinking retirement plans. I remember when I was at Henrico, suddenly the retirement plan, the good one, had at least gone away. So the incentive for a prosecutor who really enjoys and wants to do that work, frankly, it financially doesn't make sense. So how do you keep people who want to do this work and do a good job at it?
This is the part where I get to go, psych guys, I'm VRS Plan 1. Thanks to my clerkship. It's funny you should say that because I'm a progressive prosecutor and I'm very proud of that. And I'm glad to call myself that. And the knock on us is that we can't hire and we can't retain, and we're terrible lawyers. We don't know what we're doing. And a William and Mary law professor, a guy named Alan Dershowitz, did an article about a year ago that has become so celebrated in the prosecutorial community that the progressive bastion known as the National District Attorneys Association had him speak at some point this year about it. And it was called The Prosecutor Vacancy Crisis in America. And it talked about how difficult it is to get people to work as prosecutors. And one of the biggest sort of stories within the story was that there was a huge decline in the number of people going to law school, about a 40% decline after the Lehman Brothers collapse, where we saw national graduation numbers go from about 43,000 to about 34,000 lawyers per year, and stayed there for 10 years. So there are offices that are 60, 75, 80% empty. And I am full. I am turning away quality laterals. I'm turning away quality entry levels. And I'm featured by name in that article. And I don't pay the bottom of the market, but I don't pay the top of the market. So, I do okay, but my lawyers get less money for more work. But I was profiled as a national success story in Gershowitz's article. And I told him that I don't know for sure. And obviously, again, when people want a job, I accept that they will tell me what they think I want to hear. But the fact that they still have a relatively wide amount of discretion compared to other places, the fact that we don't sweat the small stuff, and that's part of what being a progressive is. We don't sweat the small stuff so we can focus on rapes and murders. And then the ability to try serious cases early. Every one of my juries is a 2-person jury, and we had 67 juries last year. We had 70 the year prior. In March, we tried 12 juries in a single calendar month this year. And what it is like new prosecutors can try their juries immediately with an OG sitting next to them, and the OGs have like the easel carriers learning at their elbow. But another big factor was, accounting for the fact that people may be just flattering me, I had a lot of people saying, I'm not applying to, and then named 2 or 3 neighboring offices that pay more. They said, I'm not applying to those places because those guys are old school. I don't want to do it like that. I want to work in a progressive office. I want to work for you because you're a progressive. And I can tell you that it didn't strike me as bunk, because the people who've said that, they get it. I don't really need to pound my ideas into their heads. They understand relatively intuitively. Which goes back to your previous point of how do I get people to implement it? It's people have already bought in before they even walk in.
What does progressive mean to you?
Sure. It means a couple of things. First of all, it means recognizing that there historically have been 2 systems of justice, and that race and wealth and power and connection has produced one tier of justice, and all of the lack or opposite of those things has produced a different tier of justice, and that the end result was mass incarceration. Everything from the disenfranchisement clauses in the Virginia Constitution of the early 1900s up through mandatory minimums, though, have meant that people who grew up like me faced a very different brand of justice if we managed to get ourselves hemmed in than poor people. And that the way to address that inequity, and by the way, that historical fact is part of the reason why the clearance rate on homicides in the United States is 60%. For every 100 murderers, only 60 are arrested and 40 walk around. Part of it is the perfect crime, but a lot of it is that people just don't trust the justice system to deliver justice. And that lack of trust has a direct negative impact on our ability to lock up murderers. So that's acknowledging the problem and identifying the problem. And then the solution is through building public trust, through implementing policies that are driven by data, policies that have documented efficacy, rather than policies that, as Bobby Scott, my congressman, likes to call it, are based on slogans and sound bites. So instead of saying, okay, you're 15 and we're going to give you mandatory life without parole because you're evil, we say, no, a 15-year-old who commits a murder is a murderer, but is not going to be the same human being at the age of 25 or 30. And that we know that criminal desistance, even with no criminal justice intervention, happens. There's a big increase in desistance at about the age of 25. And then basically by the age of 40 or 45, the degree to which people are going to commit violent crime falls completely off the table. So recognizing those things, what are we going to do? Mandatory life without parole is not appropriate, just as a for instance. And then the other thing I do, since my mom's a nurse and my daddy's a doctor, is I just talk a lot about medicine. I use medical analogies. And I say, people hooted down doctors who said that germs cause disease. Like, the medical community said that was nonsense. They also thought leeches and bleeding worked. And if you told a doctor from 100 years ago that this patient has cancer and we're going to shoot him full of nuclear radiation, they'd say it was barbaric. Those things have all been proven out to be wrong or right over time. So we don't use leeches, and we do use radiation. And that means that there are certain things that we do in the justice system now that may seem counterintuitive or wrong-headed to the general public, but they actually work. And then the last thing that it means to me is also calling out the fact that crime is not a problem. Crime is a symptom.
Right.
So obviously, a crime has massive negative effects, especially a violent crime. It is life-changing or life-ending for the victim and for the victim's family. And it's life-altering for the family of the accused, and often life-altering for the accused. But these are symptoms. If you see a spike in larcenies that tracks with a spike in poverty, maybe those two things have something to do with each other. You put the Band-Aid on the wound, but the wound will still bleed. So for me, it's also, and this is part of the reason why I think I'm kind of a polarizing figure, is I say, if you want less crime, you need better blue-collar jobs. Right. So that you can have family formation. You need better health care. You need better education. So that, like me who went to private school, like I got a great education. Like the kid who has like one parent who works 3 jobs and is as bright as we are, deserves to have an education to maximize his or her abilities. So health care, transportation, environmental justice, those are the things. We can't jail our way out. We can jail the people who do wrong. We can put them in prison. But if we're looking to change the climate rather than tinkering with the weather, then we need things to happen upstream. And that is, I think, part of the reason why we as progressives can be very controversial and very unpopular in political circles, because we throw the blame back where it belongs.
Let me ask you a question. You kind of touched on law enforcement. They tend to, as soon as you say I'm a progressive prosecutor, you turn them off. How do you continue to build that confidence between your office and the police department?
By being there and by letting the work do the talking. I've had the advantage. A lot of progressive prosecutors came out of the defense sphere and just ran for office. I'm one of a cadre. Steve Descano in Fairfax is another where we've been prosecutors. So, and I was a prosecutor in Norfolk for 9 years before being elected. So I tried murder cases. I was a property crime deputy. I was the drug deputy. I was one of the guys that, we didn't have a formal on-call system, but I was the guy that the vice narcotics detectives would be like, hey, Rami, hey, I don't know, did we get ourselves in a jam here with the search warrant we were serving it? Be like, all right, guys, or guys, your case is kind of garbage, but the guy doesn't want to take anything reasonable, and we know he's guilty, so we're just going to fucking try this thing. And fine, we go down, we're going to go down. And so I have a reservoir of credibility that way. And then the other way is by being very present. I go to every murder scene personally, day or night. Personally, I go. And I bring my line prosecutor with me, Richmond style. And believe it or not, the Norfolk police had never had this done. They were really uneasy about it when I started doing it. But the fact that I'm out there, that makes a difference. The fact that at this point, anybody with the rank of sergeant through about captain is somebody that I knew as an officer, detective, or sergeant when we were on the line together. So I came at it from a different way. And, there are times I bust down a lot of our drug cases to paraphernalia, our drug possessions, simple possessions. And, I know Vice Narcotics isn't in love with that, but I'm like, guys, I hear you, but this is just the way it's going to be. But on the flip side, it was pretty rare for us to proceed on murder one. The office, before I took office, had an institutional apprehensiveness about charging murder one. And they were like, well, juries just don't like it unless the person has a map and they're waiting in the bushes. And I've shown violent crime, the violent crime squad. I'm like, if we're going to get a jury instruction that is going to support premeditation and the defendant doesn't want to plead, it's going to be a murder one. So, being a progressive doesn't mean like automatically being a punk either. It means like the judicious and like data-driven application of force. And so when they see that I'm not just some sort of Maoist, they may not like what I'm doing, but I do have some like logic behind what I'm doing. Like they may not agree with me, but they don't like, it's not as if I walk into a room full of cops and they all turn their backs on me. Like they know me. They all have my cell phone number. They call me.
It's the communication that I think often is not made between offices, right? Between the police department and your office. You're able to talk to them and sit them down and explain why you're doing what you're doing and tell them, hey, I hear you. I know you are out there and I'm doing this from the comfort of my chair. And bringing out the human element goes a long way. And I used to see that. So you kind of touched on that, which is very powerful.
If I heard you correctly, you mentioned that you guys do you're geographically aligned. So do you all practice community-based prosecution?
Yes and no. I mean, Norfolk is a city of civic leagues, and I don't know to what extent there's a culture of civic leagues in Henrico or in the city of Richmond, but they're sort of quasi-governmental entities. And if we were going to break down to the community level, we would need people covering about 60 or 70 civic leagues. And with 40 prosecutors working their rear ends off, that's hard. I go to a lot of those meetings, though. But we have very much a geographically focused prosecution model. And the way that plays out is that we have a juvenile division because just children are just different. And that, setting aside the juvenile division, Norfolk has 2 police precincts, and therefore we have 2 adult prosecution precinct teams, each under the direction of a deputy, and each with either 2 or 3 senior assistants and somewhere around 9 or 10 assistants of various ranks. And the case assignment procedure is completely based on the police precincts. If an adult case comes in, the first thing that we do is we examine whether it happened in the first or the second police precinct. And then it then goes to the deputy of that precinct who hand assigns the case to an assistant. And that deputy, part of what that deputy's management and supervisory duties are is to like look in the case management system. Who's dealt with this guy before? Is there like a pattern? Like, is something hot in a certain area right now? And then having the line assistant aware of that, and then having the line assistant know that one of their annual evaluation criteria is, are they feeding good information back? And then we also, and you want to talk about sort of police-prosecutor relations, we have CompStat meetings. So the police department has their criminal intelligence meetings once every, couple of weeks. We're in every one of those meetings. One of the deputies goes to every single one, and we hear them tell us who the crime drivers are, what the hot spots are, who's been problematic. And this, by the way, is a progressive prosecutor criminal justice reform point. What we do is then we come out of those meetings usually with 2, 3, 5, 6 names of people who need to be jammed up because they're major crime drivers, not because of somebody's intuition, but because the police know and they can verify it. We extract punishment that's proportionate to their being a high utilizer of the justice system and a driver of criminal activity. And then that allows me in a principled way to say, okay, the other 10 guys who committed this crime, like, it sounds to me like those 10 guys can't get out of their own way. So we can work reductions, we can work, right-sized sentences. Those guys don't need to be on supervision because we have 2,100 people on supervision in Norfolk for like 40 probation officers. But it's, the reason that we do it by the precincts, Sharif, is that half the city is still 125,000 people, but I want my prosecutors to learn their neighborhoods and to learn like the blocks and the streets and sometimes the families and the family connections. If we have a gang case, for example, if we have an ongoing gang investigation, we'll usually have 3 prosecutors, one from each police precinct and one from the juvenile division, so that they're all working there's like a specialized group of defendants here, but still we're knowing how this connects with geography. So it's not straight up like we're at every Civic League meeting, but it is absolutely keyed in on, okay, what's going on in this neighborhood at this particular time.
Right. And then in doing so, you're enabling those relationships to form with the prosecutors, the police officers, and then that community. I did an internship in Philadelphia at the DA's office my second summer, and it was aligned geographically, and to me it makes a lot of sense. So it sounds like this has been awesome, and we can go on for hours, and I do have more questions if that's okay. But
I got the time, baby.
All right, and I'm sure. Well, I mean, we all know the most important question. I mean, you married someone who taught at VMI, so I'm going to ask you what the best school in Virginia is, and we already know the answer. I don't even need to ask that. But training, what does it look like for your office when it comes to training your lawyers on how to be better trial lawyers? And we already heard a part of that. A part of that was, hey, you're going to sit second chair with the person who's been doing this and is doing a good job. What else? I mean, I'm sure there's the stuff that the Commonwealth of Virginia as a whole puts on for its prosecutors. Is there anything else that you guys do?
And Ramin, I want to kind of touch on that briefly. Young prosecutors have difficulty valuing a case and what punishment to impose. And that's one of the hardest things for them. Young prosecutors, how do I know what's the appropriate punishment? And, my answer had always been, punishment, like you said, doesn't really deal with the issue. That's a Band-Aid. You got to go to the root. How do you, sit your young prosecutors down or your deputies and teach them how to value a case?
I start out with the sentencing guidelines for a second-degree murder for a person with no prior criminal record. And those go roughly from about 13 to about 22 or 23, with a midpoint somewhere around, I think, 19. No, I think I'm off by a year or two on those. So forgive me. But I also run them in front of them on paper to show them how to do it. But I say, look, this is what, in theory, the middle 50% of people get for a murder. And theoretically, there's a top and bottom quartile that falls outside of it, but practically speaking, guidelines adherence is about 80% on violent crime. So 80% of people who commit a murder get this. So now I want you to consider that third offense possession with the intent to distribute carries a 10-year mandatory. Okay? Do you understand why that's up? When we can see that, our basic rubric, our basic measure should be, what are people getting for murders? What are they getting for murders? And let's remember that as we start throwing monopoly money around about days and years and months. But the other way that I do it is through the apprentice system and through my plea agreement policies. And Norfolk, traditionally, we've been a training ground. We have turnover. Everybody, we'll lose 2, 3, 4, 5 lawyers a year, 6 sometimes, in the average year. And we're actually off that pace this year, which is frightening. I mean, so many people resigning as we're talking on this podcast. But we've always, for decades, specialized, just like Richmond did, in training young people. So having the deputies be there at their elbow, having a sort of a designated requirement that the senior assistants act as non-commissioned officers or as chiefs. They're like the E7s and E8s. We have them say, look, I can't tell you what to do, but I can strongly suggest that you not do that again, whatever that was. And then my plea agreement policy itself has bright lines. One of the things that makes me different, when I was a new prosecutor in Chesapeake, it was like, well, if you want to break this down to that, or if you want to take this mandatory time off the table, or if you want to do this, talk to your deputy because you need your deputy to sign off. For me, it's both directions. If you want to impose mandatory sentences in excess of X amount of time, you must get deputy approval. And, then there's a threshold above it where only I can approve it. And that means that it's like making sure the speed limiter is on the 16-year-old's car. Because that's what new prosecutors are. They're 16-year-old drivers, enthusiastic and dangerous. And so I have upper bounds. And, my some people who lateraled in were always like apprehensive. They're like, bro, like, I need to come to you. Like, yeah. I was like, I promise. Like, if, like, you've been doing this 10 years, our conversation is probably going to be under 90 seconds. I just want to be able to sign off on it. So when I get a microphone in my face, I can say that I knew what you were doing. But it's very, very important for the younger prosecutors. And having those thresholds built into my plea agreement policy, having them have to have discussions. And I mean, this is apart from the fact that if you're a new prosecutor in my office, we don't just give you a stack of files and tell you to go to court. Like, there is a whole like iterative process where we teach people like how to put a file together, how to know what you're missing, whom to call to fix the holes, and then how to run the guidelines, how to know what things are worth. But the fact that there are like hard guidelines, I think at least help orient young prosecutors, where it's like, okay, I don't necessarily need to know what the value of the case is yet, but I know that the mandatories this guys are charged with are above what Ramin's guidelines are, so I need to talk to my deputy. And then the deputy can use that as a teaching moment and as a moment to make sure, in a state where we do not have second look laws, we can't resentence, we can't vacate convictions, to make sure that we don't jam somebody in a way that can't be fixed on the back end.
Can you talk more about the actual trial presentation piece too? Like, what training goes into that?
But thank you for reminding me. So we use all the typical trainings, and then we also have our own in-house training. We have like a monthly 1 hour long presentation for lawyers of all ability levels. And then if we have a cadre of younger lawyers, we'll have like very basic training. Like, this is how to admit an exhibit. This is how to authenticate a video. And we will train them in how to do that. And then a lot of us have either gone to a lot of these trainings or are faculty. My chief deputy was the faculty for VACA's trial advocacy course for many years. She was the chief, she ran that course. And so we try to teach people things like, if you want to get very technical, like approach point cross-examination, or, hey, this is how to do a first close and a second close. Like, here, these are jury instructions, and this is how you use them in your first close. This is how you're rhetorically going to say something different in your first than your second. And I mean, you both, I'm sure, know approach point, like, intuitively, but like extract, on cross-examination, ask all the questions that the hostile witness is going to have to admit to, or is going to look stupid, or is going to want to admit to. Like, be friendly, and then turn the dime and start beating on them. Don't beat on them first when they'll shut down and may not give you the answers that you need on things they would have given you in a friendly way. I mean, I know this may be an unsatisfying answer, but a lot of it is art. And I try to tell my young prosecutors, like, don't try to try a case like me or like Sharif or, like whomever. Try it like you're you. And probably the best advice that I ever got in a CLE was one when I was at Kirkland, and it was a retired Minnesota Supreme Court justice. I still have the CLE materials in my office. And he was talking about civil trials. But he said, the side that wins is the side who convinces the jury that they are trying to show them the truth. The side that loses is the side that leaves the jury with the impression that they're trying to keep the truth from them. And so I talk very much with my lawyers about transparency and leveling with the jury, like not running away from problems. One of my favorite trials, it wasn't the most serious case in the world that I ever tried, but it was one of the most fun, was a robbery case, and it was an early body camera case. And my victim left in the middle of voir dire, and I had to have the cops go hunt him down and bring him back. And in opening, I said, all right, I said, ladies and gentlemen, we're here for a robbery. It was actually the getaway driver who we eventually wound up getting conviction on. And I said, look, this is a robbery. I don't know the backstory, and you won't either. None of the backstory is going to make sense. The victim is going to lie to you. None of this is going to make sense to you. We're never going to know. But what you are going to know is that he got robbed at gunpoint because the police officer pulls up and his body camera is on, and the victim is standing in his underpants at the corner of Maltby Avenue at 12 o'clock in the afternoon. And the police pull over the getaway driver's car with the victim's pants in them, and with a gun, and with the victim's ID. So, and you'll have a cooperator. So he will lie to you. But what you're going to be able to understand based on the evidence is there was, in fact, a robbery. Guilty. As a new lawyer, I would have been like in absolute amazement if somebody said, no, just go in there and just say the victim's going to fucking lie. Like, that's the way to win this trial. But sort of the authenticity and the ability to sort of know your own strengths and weaknesses and the ability to level with the jury are other things that we try to teach. Another thing that I do, for example, in voir dire, which I consider to be probably the most important part of the trial, is I mix up people's names. And so I'll be like, all right, Mr. Abuzaki, I'm probably going to call you Mr. Gray at some point. Like, sorry about that. I also guarantee you at some point during this murder trial, I will call the victim by the defendant's name and I will call the defendant by the victim's name. And I'm really sorry about that. It's not you, it's me. And I guarantee you that I'm going to lose all of my exhibits on counsel's table. That's why Mr. Gray sitting next to me is here to help me out. And I do both of those things regularly. and what happens is when instead of it being like a highly insulting moment when I do that, I kind of look at the jury and and it's the same thing. I'm shuffling papers. I look up and I go, and they look at me and they go.
Oh my God.
So I tell the prosecutors to like know yourself and to make sure that you're authentic, because that makes you the side showing them the truth rather than hiding it. And then the last piece that I tell them is treat the entire thing as an extended conversation. And this is part of what we do in our training. Opening statement is a conversation. Closing statement is a persuasive conversation. But direct, it's a conversation. Like, the best direct examination sounds like an organic conversation between a person who is unaware of the facts but is interested, and a person who is prepared to enlighten or educate the inquisitive person on what's going on. And sort of the art of how to do that is another big thing that we try to teach prosecutors. Like, well, so you exited your unit and the defendant was no. So, officer, were you patrolling that night? Yes. Where were you? I was on Alexander Street. What city's that in? That's in Norfolk. Did you end up stopping anybody? Yes. Who? Sharif Gray. Is he in the courtroom? Yeah, he's right there. All right. Ladies and gentlemen, you can see that, just the ability to make it conversational instead of to make it technical is another one of those practice points that we train our lawyers on when it's either at the deputy level or at the me level. And I'll go and watch trials. And my lawyers have gotten to the acceptance phase of grief where, like, they know that if I've seen a part of their trial, like, they're going to be in my office and I'm going to be like, okay, this isn't Ramin the Commonwealth's attorney. This is Ramin the deputy Commonwealth's attorney. And let me just tell you, like, you did this good, you did this bad. Like, here's some practice points.
Well, you guys probably don't need this then after hearing all that. But actually, now the podcast is hosting a conference in Richmond called Voir dire to Verdict on October 24th, where we've got speakers from all around the country, starting off with, I think our sessions now, correct me if I'm wrong, Session 1 is authenticity in the courtroom. Session 2 is case framing. Session 3 is voir dire. Session 4 is using graphics and visuals. Session 5 is opening statement. Session 6 is direct and cross. And the last session of the day is closing like a closer. So closings and rebuttals. So if you want to come and join us or send some prosecutors, we'd love to have you. Happy to share the information. But from what you've just shared with us, it sounds like you don't need it.
We all need training and retraining, education and re-education. So send me the information. I'm sure you guys are going to put on an excellent conference. So I'm interested.
Ramin, let's talk about the trial. So we touched a bit about the training of the trial. Now I want to talk about Ramin, the trial attorney. We often ask the question, first, what do you think is the most important part of the trial? And second, what is your favorite part of the trial?
Well, I already kind of boxed myself in by saying it's voir dire, and I really do think voir dire is important if you accept that framing concept of like the side that's telling the truth versus the side that's hiding the truth, especially as prosecutors. And by the way, every training I go to, I play the defense lawyer. And I did it when I was a Fed. And they were like, whoa, man, you missed your calling. I was like, I didn't miss my calling. I just know how to do that job. As a defense lawyer, you can have personality. Like as a prosecutor, it's very circumscribed. So the only place that we as prosecutors really get to connect on a human level with the jury is during voir dire. So to be able to have that back and forth and interaction with people, to have a conversation where it's not scripted, I think that is very, very important for framing the rest of the case. And if you're in a jurisdiction where the judge gives you a little bit of leeway in the way that you frame your voir dire, that makes a huge difference, because then you're already drawing some of the poison out of your problems, you're bolstering some other pieces. If you have a non-stranger sexual assault, which I consider to be probably the most difficult of all trials to put before a jury as a prosecutor, to be able to say during voir dire, well, I mean, one of the things that you're going to hear is that the victim in this case, Miss X, knew the defendant. They knew each other, and they had a history. Will everybody be able to follow the instruction that the judge gives you? That simply knowing the person and having had previous intercourse with the person does not excuse a subsequent rape. Can you follow that instruction? So to be able to sort of use those pieces up front, it's basically allowing you to do your closing argument during voir dire, because anytime you're framing the terms of any kind of debate, you're winning the debate. You call it the millionaire's tax, you win. You call it the death tax, you lose if you're trying to tax it, if you're trying to push the estate tax. If you call it reproductive health care and you're pro-choice, you win. If you're calling it baby murder and you're pro-life, you win. If you can get the other person to adopt your term. For me, it's kind of hard to pick a favorite. It's like picking a favorite child. But I also love closing. I absolutely love to close. And I love rebuttal closing more than I like the first closing.
Oh, the gloves are off, right?
Oh, yeah. Well, and that's the can you believe this shit phase of the trial whenever you're a prosecutor. And, because my lawyers have learned that I do have certain things that if they don't do it during their first closing, they're going to be in my office and I'm going to be grumping at them. And that's another management thing that I got. I had a lot of sphinxes as managers, and I tell my lawyers, I'm like, look, if you come into my office and you say, look, I screwed this thing up, and I'm like, yeah, out of a 10, that's probably a 2. Yeah, don't do that again, but don't worry about it. I'm not mad about it. Like, you can take it to the bank, because more than one prosecutor has been in my office and I've said, do you understand how angry I am with you? Like, do you understand how angry I am? Because what you did is absolutely, completely beyond the pale. Like, and I mean, I won't verbally abuse them, but I won't hide my anger. Like, I'll be like, I'm angry at you, and this is why I'm angry at you, and you, like, this is elementary stuff that you just did, or how am I going to explain to the public, like, what you just did? Right? And so, it's maybe a 2 out of 10 for close. Like, I want to see those jury instructions up on the Elmo, and I want you walking the jury through those jury instructions. Ladies and gentlemen, we told we told you that the defendant took advantage of Miss X's night of heavy drinking to rape her. Though that's the legal term, and that's what the facts demonstrated based on what you saw today. Now, there's a legal definition of rape, and it's in your jury instructions. Here they are. Let's go through them. Some of these things are not in dispute. A, B, and C are not in dispute because the defendant admitted all of those things. It's D that we're going to focus on, and here's how to drill down on D. For example, if it's consent, there's no question that the defendant penetrated the labia of the victim with his penis. The only question is, was it through force, or incapacitation, or intimidation? And remember that incapacitation means this. The defendant has already admitted everything but those last things. He's just saying that she let him. Now let's talk about why those facts don't line up here. But second close is the best, because it's just like, all right, ladies and gentlemen, here comes the conspiracy. You knew it was coming. Now let's talk about it. Or, this defendant is either guilty or he's the most unlucky person ever to walk the earth. Or, oh, no, it's ladies and gentlemen, remember, it's reasonable doubt. Now let's explain how utterly unreasonable everything you just heard was. The defense lawyer is doing the best with what he's got. He's working with what he's got, but that's it. That explanation fails the laugh test. I don't even know where to begin. And to be able to do that, like I said, like, can you believe this shit per portion of the closing is always fun, because it is one place where we can betray a little bit of righteous indignation beyond sort of the sort of low cold-bloodedness that is necessary for most prosecution. I'm also better than average on my feet and thinking on my feet, so that plays out more in closed than it does in open or in direct.
Right. Absolutely. Well, I mean, we've been going, over an hour, and I'm confident that we could keep going. Anyways, if you could go back in time to when you're graduating from, it was Columbia Law School, right? And say, hey, I want you to know A, B, and C, what would you tell yourself?
I guess I would say, I went to law school I started in the fall of 2000, and I remember encountering basic concepts from criminal law and being what are we doing in the war on drugs? This doesn't make any sense. The way that we're operating this doesn't work. And then sort of putting that out of my mind and just being well, I can't say that out loud because I'm never going to work as a prosecutor anywhere. I think what I would say is, and if we're confining it to I can't engage in insider trading, buy Dell, a lot of Dell, buy Google.
Right.
But beyond that, I would say to tell myself that I was coming out in sort of the tail end of a dark era for criminal prosecution and criminal law in general, and that it was going to stay bad for a little while, but that the heart of my career, the part that includes my time as Commonwealth Attorney, is a really important dialectical phase, one where the old sort of mass incarceration consensus has broken down, and where there is a lot of energy going into figuring out what went wrong in the 1990s, both in terms of crime and in terms of punishment, and that it's really important to be focused on the individual cases, but that I would have the pleasure and the privilege of doing this work at a time when people started figuring out that the old ways weren't working. So,
well, it's been a pleasure. Now, do you want to close it out for us?
Appreciate what you do for the Commonwealth of Virginia and the citizens of Norfolk. They're lucky to have you. And I will tell you, working in different Commonwealth attorneys' offices throughout the Commonwealth, what you're doing is not being done. I hope that energy, that fresh energy of you taking this office, over this office and leading your prosecutors to where they ought to be, where they don't know where they're at, but you're taking them to places that they don't, that's new for them, continues on. And we appreciate you so greatly and keep fighting the good fight.
Well, Judge, thank you for having me on. Sharif, thank you for having me on. It is a pleasure to speak with both of you. To be able to talk to two seasoned trial lawyers who really care about doing the work and get to talk shop, I've really enjoyed it. Thanks for making the time for me.
We appreciate it.
Thank you.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.